Welcome back, 1Ls. I'm going to be your peer tutor today to help you navigate the tricky waters of your contracts class and build a completely exam-ready cheat sheet. Look, if you've been sitting in lecture feeling like contract law is literally just a series of traps designed to catch you off guard, don't worry, you are absolutely not alone. In this explainer, we're going to break down some of the most tested and honestly most misunderstood concepts from Week 3B of your syllabus. My goal? To make these rules so clear and visual that you'll spot the issues on your final exam from a mile away.
Let's start with your professor's classic hypothetical. Read this right here. Is this a real promise or just an illusion designed to trick you? Think about it for a second. I will sell you my book if I feel like it. Well, have I actually restricted my future course of action at all? Have I committed to anything? The answer is a resounding no. Since my performance is entirely discretionary, this is exactly what the law calls an illusory promise. I have absolutely no legal obligation to hand over that book.
Here's our study roadmap for today. 1. Spotting illusory promises. 2. Output and requirements contracts. 3. The pre-existing duty rule. 4. Modifying contracts. And 5. Accord and satisfaction. Let's get into it.
Section 1. Spotting illusory promises.
So, learning to spot a promise where the promiser has zero actual obligation is crucial. Why? Because if a promise is illusory, there's no consideration, and no consideration means no legally binding contract. Simple as that. Let's break down the math of contracts. A promise to pay $500 and a promise to love me. That has value. The promise to pay $500 has clear legal value, even if the promise to love me doesn't. You just add them together with that crucial word and the whole package is supported by consideration. But a promise to pay $500 or a promise to love me, that is a classic illusory trap. If there's an or, I'm reserving the right to choose the alternative with absolutely no legal value. If I can just choose to love you instead of actually paying you, I haven't bound myself to any real legal detriment.
Now, as a tutor, I love a good checklist for memorization. So here are the strict elements you need for an option contract, which is a major exception you'll definitely see to the standard consideration rules. Under Restatement Section 87A, to make an offer binding as an option contract, it must be in writing, signed by the offeror, recite a purported consideration, and propose an exchange on fair terms within a reasonable time. If you hit all 4 of those marks, boom, you've locked the offer open.
Okay, let's look at a true classic, a case you will 100% see on your syllabus. Wood v. Lucy Lady Duff Gordon. In this one, Lady Duff Gordon gave Wood the exclusive right to sell her branded clothing. Later on, she tried to get out of the deal by arguing that Wood never expressly promised to do anything in return, which would make the contract totally illusory. But the court actually saved this exclusive dealing contract from being an illusion by implying a promise. Because Wood had an exclusive right, the court said, hey, he impliedly promised to use his best efforts to sell her goods, and that implied promise, that provided the necessary consideration.
Moving right along, Section 2, Output and Requirements Contracts. We just saw how courts imply terms to save a contract. So now, let's look at how we handle contracts where the exact quantity of goods isn't perfectly stated up front. I'm going to give you a huge shortcut for your exams right now. These strong words of obligation you see here are the magic words. They prove you have a valid good faith output or requirements contract under UCC Section 2306. If a buyer says, I will buy all the steel I require, or a seller says, I will sell you everything I produce, that is absolutely not illusory. Even though there isn't a specific number attached, the UCC says the quantity is measured by actual good faith output or requirements. They've legally restricted their future actions.
Now compare those to these highly ambiguous words, which should be massive red flags for you. They indicate you only have an illusory continuing offer until an actual order is placed. If a buyer says, I'll buy all the steel I want, or all I wish to buy, well, they haven't restricted themselves at all, have they? They can just choose to want zero. So this isn't a binding requirements contract, it's literally just an offer that stands open, waiting for them to place a specific order.
This perfectly illustrates the crucial timeline difference between those two concepts. A true requirements contract forms one continuous binding agreement for the entire stated duration, let's say a year. Neither party can just walk away. But a continuing offer, based on a word like want, just forms a series of individual acceptances. Think of them as A1, A2, A3, forming completely separate mini-contracts whenever an order is actually placed. And crucially, that continuing offer can be revoked at any point before the next order is made.
All right, Section 3, the pre-existing duty rule.
This strict common law doctrine deals with past consideration, and let me tell you, it traps students on multiple choice questions all the time. The absolute crucial point here is that promising to do something you are already obligated to do has zero value in the eyes of the law. Why? Because the law refuses to reward parties who basically hold out for more money. Imagine a builder agrees to build your house for $100,000. Halfway through, they stop working and say, "Actually, I need $20,000 more to finish." If you agree, your promise to pay that extra 20 grand is generally unenforceable under common law, because the builder is only promising to do what they already had a pre-existing legal duty to do.
Which brings us to Section 4, modifying existing contracts.
So, what happens when circumstances genuinely change, and we really need to modify a deal without adding new consideration? The law recognizes that, hey, business happens, and sometimes strict adherence to the pre-existing duty rule just isn't practical. Grab your highlighters, because this is the UCC exception that proves the rule. If you're dealing with the sale of goods, meaning UCC Article 2 applies, you do not need new consideration for a modification to be binding. The only requirement is that the change is done in good faith, with a legitimate commercial reason, and definitely not as an attempt to extort the other party.
Now pay very close attention to the jurisdictional split here. If you're under common law, like for an employment contract, real estate, or services, instead of the UCC, the rule is way stricter. A modification without new consideration is only valid if it meets Restatement Section 89A. It has to be fair, equitable, and address unanticipated circumstances that arose after the contract was made. If the circumstances were completely foreseeable from the get-go, the modification usually fails.
Finally, Section 5, accord and satisfaction. Let's tackle how to resolve disputes right at the end of a contract's life cycle. This is for when someone can't pay what they originally promised, but they really want to settle the matter without dragging it into court. Please don't let these terms trip you up on an exam. They are two very separate steps. The accord is the agreement itself. It's the agreement to accept something different to satisfy an existing claim. For example, I know I owe you $1,000, but will you take my used car instead to settle the debt? If you agree, boom, that's the accord. The satisfaction, on the other hand, is the actual carrying out of that performance, literally me handing over the car keys. The original debt is not legally discharged until the satisfaction is fully complete.
Now we're making a rare jump into UCC Article 3 for this class, which governs scenarios where a physical instrument, like a check, is used to settle a debt. Here is the absolute golden rule for this to work. The debt must be subject to a good faith dispute. Look, if everyone completely agrees I owe you exactly $1,000 and I send you a check for $500 that says payment in full, cashing it does not discharge my remaining debt. But if we legitimately disagree on how much I actually owe and I send you that payment in full check to try and settle it, that's when UCC Section 3311 kicks in.
So if you receive that payment in full check on a disputed debt, you basically have a choice: cash it and settle the debt entirely, or return it. A massive, massive trap for students is thinking you can just cleverly write under protest or without prejudice on the back of the check, cash it anyway, and still sue for the rest of the money later. No way. UCC Section 1308 explicitly states this does not save you. Subsection B plainly says that writing under protest simply does not apply to an accord and satisfaction. Bottom line, if you cash the check, you accept the settlement regardless of what you scribble on the back. Wow, we have covered some immense ground today, from spotting illusory promises to settling debts. I want you to really think about how all these rules interact out in the real world. So let me leave you with this little puzzle to ponder. If a continuing offer, like someone saying I'll sell you all the widgets you want, can be revoked at any time, what actually happens to the individual widget orders that were already placed and accepted before that revocation happened? Keep that tricky timeline question in mind as you prep for our next explainer session. You've got this, 1Ls. Happy studying.